Bob, I've got a question.
Sure.
With this contract, there are limited finances, and I'm trying to use my resources where they're best suited. Please, I know there are some issues, I've won PCRs on pleas before, but they're limited. Could you enlighten us to, like, points that you've seen work out in a guilty plea? Because invariably, I have a client who's like, go get my discovery, get the whole file, review it, retry my case, when it's a plea. When the factual, that's pretty limited. I mean, I feel like that's mostly a waste of my time, but where would it not be?
Well, I think particularly years ago in the old days, you know, a lot of it was on just bad sentencing or parole advice. I mean, you know, there was plenty before they kind of some of that stuff got kicked over, right? Yeah, al-Shabazz and all that, but bad sentencing advice where, you know, the court was always saying constantly, you don't have to get into this area with the client and say you should assume you're going to serve every day of it. But if you give sentencing advice, it's got to be accurate. That, as far as guilty pleas were plea offers conveyed to the client, were they told when the plea offer would expire? Those kind of things have been brought up. Some lawyers do a good job. He used to, you know, I think it's an old case with old Judge Epps one time on direct appeal of Bertha Robinson and her Bertha Robinson's mother's up there testifying, and the solicitor objected to something being hearsay. Judge Epps said, "Ah, come on, everybody knows there's no love like a mama's love." But sometimes having mama or brother and sister there to just back up and say, yeah, the lawyer conveyed this plea or said you have till this date to accept it, and if that's wrong. So those are the type of things, bad sentencing advice, plea offers not getting passed on, those type of things on guilty pleas. I mean, the bad old days, there's one lawyer over at Lance's former office before Lance, but, you know, he would always go, it's like shooting fish in a barrel, you know, when you told the judge you were guilty, are you lying now or are you lying then, you know? But, so that's what I see, bad sentencing advice, not properly passing on plea offers. Anything else y'all want to chime in about it?
I mean, I think that's got to be one of the hardest things, because we're trying to tell you what we can see. And one of the things I always tell my clients, he'll always say, well, my trial lawyer didn't do this and do this, and so is lying, and so should have come. And we can't see that because we just see the record, that's all. And so a guilty plea, there's no record at all for you to go off of. So, I mean, that's an entirely extra record investigation that needs to be done. And I guess the only way to do that is, I mean, I would think of it as almost taking your client's deposition and just drilling into them about what specific thing is there that you think your trial lawyer did.
Susanna, another thing along those lines, I mean, one thing I always tell my clients on direct appeals, a lot of PCR is what you can't see in the record. And I mean, we're talking to Dave Davids, and that's how I'm going to finish briefly here on what you can spot from the transcripts. But you know, you hear a million times just kind of what else are you going to say. But I only pled guilty because I knew my lawyer wasn't ready for trial. And you hear that constantly. But obviously, there's got to be meat on the bones. Well, you know, who did you ask him to talk to? Well, I asked him to talk to Rodney, and they didn't talk to Rodney. Well, I got to bring Rodney in as a witness, and what would Rodney have told the attorney had he contacted the witnesses that he asked him to? But what we see, it's better definitely than it used to be in the Wild Wild West days, but I told him to talk to Johnny and Bug. And what's Bug's real name? I don't know, you know, and it never gets fleshed out. Bug's got to be there to testify. You know, Black's got to be there to testify.
New York.
New York.
Monkey Punch.
Peanut.
Oh, sorry, what was the last one? Monkey what?
Monkey punch.
Okay, monkey punch. They all gotta be there, bug, black, monkey punch, and here
Punch
you
like a
are.
monkey, ass right.
They all gotta be.
I just filed an appeal from a PCR dismissal. I don't know who will end up with it. But it was on a guilty plea. With trial lawyers just did a crappy job. I mean, no investigation. I mean, and
Hey, I'm in the room.
a case I probably would have taken to trial.
Yeah.
You know, if I was representing her in the criminal stuff. And, you know, and that lawyer kind of folded, and of course, she folded. But I think it's a pretty darn good record about how crappy the trial lawyer. Just no investigation, and I just don't know how meritorious that might be on appeal, so.
I lost quite a few on Brady violations when I was at the AG's office. Especially for guilty pleas, and especially when the solicitor says I have an open file policy but has no record of ever giving any of the information over to the other side. Because an open file policy means that's for Brady.
Yeah, that's a good point on Brady also. Okay, I'm just going to cover real briefly here, not much time on just the charge conference till the end of the trial. On your request to charge, when you're going over these for your PCR record, obviously the first thing you're looking for is, are there lesser included offenses that didn't get charged, and if not, why not? You know, if it's a murder trial, obviously, you know, voluntary manslaughter, involuntary manslaughter. You know, a lot of times, maybe that's the wrong word a lot of times, but these things take place in chambers or take place somewhere because there's vague references to a charge conference. But it's the trial lawyer's job to get those charge conferences on the record. I mean, that's their job. What was discussed as far as lesser included offenses, what was discussed as charged as jury charges you wanted and you didn't want. So if you're reading through the jury instruction, and please obviously read the jury instruction. It's frustrating on appeal because I actually say to the court often, you know, there's close enough in hand grenades, horseshoes, and jury charges. Because the appellate court likes to go, well, the charge as a whole sufficiently covers that. It's very frustrating on direct appeal, but there's law that is good that says merely superimposing good law over bad law or bad law over good law is just confusing, and it is. So if you read jury instructions and you see things that just strike you as bad. Jim Falk one time, Jim called me up on something and said, you know, what about this? And I looked at it and said, damn, you know, you're right, that's really bad. You know, so if something strikes you as bad, your intuition is probably right. But again, you look back and if it's never discussed on the record, that's somebody's fault. And it's, you know, we're the appellant, we get blamed for everything that's not on the record. Now again, the standard for lesser included offense is any evidence of that lesser included offense in the light most favorable to your client. Justice Paconis, when he was on the Supreme Court, always would say, why not discharge it? Every trial judge has probably made that mistake. That's BS. They don't say it on the record, but that's BS. I don't believe that. I'm not going to charge it. Like Michael Light ended up winning that case. And he said his girlfriend goes into the bathroom, takes a shower, comes out with allegedly another woman's hair, confronts it about her. He's got the shotgun in his hand because he's scared of her, even though she doesn't have a weapon. He accidentally shoots her when she grabbed for the gun, and he did it in self-defense because he thought she was going to hurt him. So he did the natural thing of loaded her body into the trunk, drove out to the middle of Texas, and dumped the body into the woods. Of court refused to charge in self-defense and involuntary, and the court at oral argument was like, well, there is evidence of self-defense, there is evidence of involuntary, and granted him a new trial. So again, the evidence is any evidence in the light most favorable to your client, even if it's conflicting, like State versus Max Noten, he couldn't decide whether, you know, he killed his girlfriend intentionally, unintentionally, whatever. But each of those statements, and I know that's not obviously it's horrible trial strategy to throw it all up there and let the jury decide what it believes, but nonetheless, any piece of evidence that provides any evidence of a lesser included offense gives trial counsel the right.
Let me ask you, Rock and I were having an interesting conversation the other day. You're taking this any evidence for lesser included, but what if you go to the assault and battery statutory scheme where everything is statutorily lesser included? If I have an ab-hand case, should I ask for everything down to simple assault and battery?
I mean, I love Gerald Malloy, Senator Malloy, but some of that stuff just gets to be confusing as hell. Susan once had the case where they had
You're welcome.
no, that's all right. It wasn't her fault. But they found harmless error under these bizarre facts from the failure to charge a lesser included offense. And that's where we win the most, is on where the trial judge does the natural thing of going, that's just BS, I don't believe that, and I ain't gonna charge it. But that ain't his job or her job. That's the jury's function. But yeah, on the statutory ones, it just doesn't meet. Some of them to me are real weird, I'll be honest with you.
I agree some of them are, and maybe on the evidence they might not fit, but the statute says it's a lesser included.
Well, if the statute says it, then you're
right, that's a,
yeah.
So you should ask for every last one of those.
Well, I mean, those again, I mean, as far as, you know, trial strategies like anything else, you know, if you want a murder case, if you want to ask for voluntary, you know, I get it, you know, some of it's going to depend on your judge, and it's like, well, jury thinks you've given him a break, convicts him of voluntary, and the judge is going to give him 30 years anyway, which he's going to do day for day. He's going to be dead before he ever gets out of jail. So, I mean, some of that is, you know, legitimate strategy, and, you know, some of it, Judge Conduras is at PD convention a few years back, said, you know, it's not hard to figure this out. All y'all who are on salary go, oh, I screwed up. Damn, I should ask for the lesser included. And said all of them are who are retained, says one of my favorite PCR testimony, a very good trial lawyer too. And they said, well, why didn't you do such and such, or why didn't you request this? And he said, I don't remember, but whatever I didn't do it, it was strategic. True story. But, you know, I get it, some of it's, but what was that discussion had with your client on what the lesser included carries? Do you want it? I mean, all those are things, obviously, talk to your client, you know, in advance as far as, you know, how that's going to get played.
Of course they wanted it. And PCR, they.
Oh, yeah, I get it. You know that, Susanna, and the judge knows it, we know it. But yeah, I mean, did they make an informed decision whether or not it was asked for? I think is the key. You know, when you read through jury instruction, is a jury instruction justified? One of the worst, I think, abuses of all time, to me, is the hand of one is the hand of all instruction. Because, you know, a lot of jurors and tried solicitors try and sell them on, you know, if you and I are together, we go into 7-Eleven, you don't even know I have a gun, that because you're with me, you're responsible for everything I do, whether there's any way of it being foreseeable or not, and obviously that's not the law. You know, and so you're looking for, if it's not clear that there are two people acting in concert, was there a coherent objection to the hand of one, hand of all charge? I very rarely see it. 28 years of doing it, rarely see an objection to the hand of one, hand of all charge. So look at that closely. Was the jury instruction unconstitutional charge? In fact, unconstitutional under our state constitution, which said judge shall charge the jury on the law, but not the facts. So again, State v. Stooks, Cat had that, Witherspoon, I had it. We did this for years and years, fortunately, because trial attorneys, some of them, did a good job. The testimony of the victim need not be corroborated in prosecutions for criminal sexual conduct. For years, we told the court that's horrible instruction. It's unconstitutional to charge on the facts. A year ago, they bid on it in Stooks and Witherspoon. So obviously, if you ever see that horrible jury instruction and it's not objected to, there's a major issue. Now, again, the trial was before Stooks or Witherspoon. You know, Justice Toll always had that line, the lawyer doesn't have to be clairvoyant. But speaking of rock, you know, and like stuff, if you're on the SCACA listserv, which I no longer am, but you know, a lot of these ideas are out there on the listserv for criminal lawyers well before the court ever decides them. So I wouldn't accept this the date of when these big cases come out, like Belcher. Everybody knew that argument of Belcher on implied malice from the use of a deadly weapon was out there a good time. There it is, inference of malice from the use of a deadly weapon, improper and self-defense case, lesser included accident, and these are the court's own words. Second slide there. Use of a deadly weapon, implied malice. Instructions: no place in murder or ABIK case where evidence is presented would reduce, mitigate, excuse, or justify the killing, or the ABIK case. So be alert on the Belcher, Stooks, and Witherspoon and child sex case.
No, and again, I defer to y'all's appellate expertise, but when these decisions come down, can people on PCR benefit from those even though it wasn't the law at the time?
Well, that's
of their
what I'm
trial?
saying. The court generally, and the judges are going to react as the appellate court. Well, that wasn't out at the time. So, you know, you look like, you know, in some cases, I think Belcher among them, they specifically said, this is only perspective and you can't do it. But to the extent they don't bar it, if there is discussion in your inner circle of criminal attorneys, like I think, you know, most of us who do this, we knew Belcher was out there.
Well, the Constitution was out there. That's what irritates me. It's like, well, that case wasn't there, but this was the Constitution, so that, if that person argued it, they would be that case.
Right.
And here's kind of a good segue, I think so myself, is, you know, here's one that hadn't gone on, but you know, the other part, not the deadly weapon, but you did it without justification or excuse. You know, that's kind of a horrible jury instruction. You know, what if you got, I had a case one time, State versus Lord Byron Slater, what a great name, Lord Byron Slater. But you know, he was there at a gym, had a dance, and after the dance, he goes, we're just shooting up in the air and shooting out in the air generally. And they said, well, why? What are you doing that? He said, oh, it's just something young people do after the dance or something. But, you know, some of these, why should doing something totally stupid where you're not trying to hurt something, anybody, lead to an inference of malice? Which, you know, that's horrible. An inference of malice is, you know, that the judge is doing the jury job for him by him. So any kind of inference or implication charge, just like back in the, you know, Sanford v. Montana in 1979 for presumptions. Anytime you get into inferences or malice, implied anything instruction, take a good look at it. Because just like the lawyers back then were ahead of their times on presumptions, I think we need to be ahead of our times on implications or inferences.
Pop,
Yes, sir.
may I interject?
Yeah.
Something right here. One thing I've seen in our case law that sometimes judges will charge is that you can infer malice from an unlawful act. I don't think that's a correct state of law. And where that comes into be a big problem is if they're charging that when they're dealing with something like a status crime, like possession of a firearm or drugs. I mean, one case that I can remember where the client was there, he admitted that he was there for a drug deal, but the defense was that the co-defendant had decided at the last minute to rob the guy and murder him. You know, he got that unlawful act charged, and I think honestly the evidence could go either way in that case, but they could have easily convicted him just because he was there to do a drug deal if they could have inferred that malice and transferred it from his co-defendant to him. And I've got one of those on direct appeal right now where the judge charged that just based on the status crime of having a gun. So look out for those inferences, they're deadly.
And here's one on Seek the Truth instruction, State v. Beatty, speaking of Rock, and Charles Gross had this case. It's pending on rehearing of both parties. But they finally did something which Seek the Truth. Your job is to seek the truth. That's a horrible jury instruction. If you talk about down the PD convention, that goes back to State v. Scott Needs, State v. Bay and Oleski, and the death penalty case for about 20-something years. We've been saying, put a stop to this instruction. It's horrible. Your job is to seek the truth or find out the truth. How are you going to find the truth when everybody's lying out there? You know, I mean, you know, you can't. And that's not their job. Their job is, their only thing is to decide whether the state's proven the defendant's guilt beyond a reasonable doubt. Seek the truth just makes a reasonable doubt instruction into a civil preponderance of the evidence standard. So now it's out there. Whatever happens with Beatty, the court has said this is a bad jury instruction. You need to object. And you know, appellate court at times, you know, they'll have the, you know, appellate games of, well, it wasn't charged during the same time as a burden of proof and reasonable doubt instruction. You know, so what? You know, to me, it's even worse in the beginning of the trial where the jurors are said, your job is to seek the truth or find out the truth. Right at the beginning of the trial, the jurors are being told, you have to figure out what the truth is amongst a multiple of lying people that you're going to hear from in the next couple of days. So that's a bad jury instruction. If you ever see it, opening instruction, call it what you want, opening charge on the law, opening statement, it doesn't matter what you call it, it's bad. The more specific a jury instruction is, the more it needs to be examined as a charge on the facts. Example, I had an old case, John Kennedy Huey, we all might remember, and you know, unfortunately they filed our jury charge. At that point was a charge on the facts because it talked about somebody spitting at somebody could be proper for voluntary manslaughter, which it can be. Or, you know, grabbing somebody by the ear and leading them around. You don't see that much anymore. But I went to Catholic schools and I saw many nuns grabbing people by the ear and leaving them around. So that can, but if you get too specific in a jury instruction for the prosecution or the defense, it's likely to be a charge on the facts. If a defense request to charge was denied, was it properly supported by case law and a coherent request? Again, if any of the case law in support of the jury instruction is bad, the appellate court is just going to say it wasn't all good law and there's no error. Again, jury instructions, where supported by the law, mostly drug cases, but other cases, well, you're entitled to a mere presence charge. Mere association, you know, like David Alexander hanging out with me or something, that's probably ought to be a crime, but it ain't. Mere presence, mere association, mere knowledge that a crime is going to be committed. This goes sometimes into the hand of one, hand of all. These are under State versus Madison, which the court affirmed is modified, and again said, well, they were generally covered, but again, that hand grenades, horseshoes, jury charges, instruction shouldn't come about, but you're entitled to these, so look if they're supported by the facts. Very briefly, closing arguments, always read them carefully. The state at times gets away with horrible golden rule arguments, and it's time, you know, they talked about Justice Fee, talked about Willie Reese case down there, you know, who's going to do justice for his widow, and, you know, all that stuff is improper. I had a case out of Richland County, Carmen Rice, and, you know, he the guy who got killed was kind of, you know, playing around on his wife and everything, and solicitor, then Johnny Gasser, not Johnny Gasser, then it was Johnny Metters, was able to turn it around and to kind of have pity on the widow, kind of urged that they return a guilty verdict. So you see these improper, and again, if it strikes you as really bad, it probably is, it is bad, and it's legitimate to ask trial counsel why they didn't object. Again, seek the truth, search for justice, all those are bad jury instructions. Self-defense, always take a close look at any self-defense case under an old case called State versus Albert Fuller. There's a site to it. Albert Fuller, you can just run Fuller, Bruck, Bloom, Swirling, those are the attorneys on it. You know, you get it, you're entitled to a jury instruction if your facts fit it. You do not have to wait for the other guy to get a drop on you before you pull the trigger. You get to continue to shoot until the danger is past. David and I had a case in the Supreme Court where a trial solicitor came down and argued it. He's like arguing the Supreme Court, which was like arguing the jury, which you don't do. He's up there, he shot him twice, not once, twice. You know, it doesn't make any difference. If you have the right to pull the trigger the first time, you keep shooting until the danger is past. This is actually out of Fuller. Defendant, you're entitled to this if the facts match. Defendant must show he believed he was in imminent danger, not that he was actually in danger, because he had the right to act on appearances. And under the circumstances, as they appeared to him, he believed he was in such danger as a reasonably prudent man would have. State v. Logan, this is a very important case on circumstantial evidence. Now look at this. If the trial lawyer asked for it, when requested by the defendant, you are entitled to this charge, in addition to a proper reasonable doubt instruction. That's important because appellate court should be precluded from saying, well, you got a proper reasonable doubt instruction, so it doesn't matter. Court's saying, no, in addition to it, you're entitled to this instruction. What instruction? There it is. Two types of evidence, direct and circumstantial, blah, blah, blah. Here's the key part, though. Crimes may be proven by circumstantial evidence. Law makes no distinction. That's the worthless Griffin charge. Now, get past Griffin. However, to the extent the state relies on circumstantial evidence, here's the key language. All of the circumstances must be considered with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances portray your defendant, your guy's behavior as suspicion, the proof has failed. You are entitled to that in a circumstantial evidence case, and I don't know why in the world you wouldn't ask for it. Very briefly, we talked about Belcher, Brock's old case. Suicide is a big issue. It's pending in a Supreme Court case called State v. Cartwright, who is my client. His son was named, believe it or not, Hoss Cartwright. True story. But I really find that, I find the suicide instruction offensive, that somebody can take the fact they attempted to commit suicide as evidence of their guilt or guilty now. People attempt suicide for a variety of reasons. despair, and I hope the court puts an end to this, but suicide's being talked about, the court's got it, we'll see what happens. State v. Grant, a very old case, the solicitor can argue flight as evidence of guilt, but it's totally improper for the jury to be instructed on. Very briefly, State v. King was argued about 8 months ago. Court of Appeals held that specific intent is required for attempted murder. Again, specific intent is required for attempted murder. That is the law out there now from the Court of Appeals. It was argued about 8 months ago in the Supreme Court. Again, hand of one, hand of all. I put it in here again for emphasis. It can be a horrible jury instruction. Anytime you see it, be on the alert. Allen charges. Are they addressing the minority, the 2 or 3 or 1 juror holding out? So anytime you get an Allen charge, look at it very closely. Does the judge and the attorneys parties know the split? Obviously, if they do, if it's 11-1, you got to really, or 10-2, you got to really scour that jury Allen charge to single out the people who are holding out. Good character instructions, you're entitled to if you present evidence of good character. We don't see it much at appellate defense, I don't know why. But
Can't imagine any reason.
Can't imagine any reason, but
I have it on appeal.
got it on Susan's got it on. But every now and a blue moon we'll see. But if you put up good character evidence, I know you can blow the door off the hinges, but you're entitled to the instruction. Sentencing, sentencing is a legitimate PCR issue, not just in death penalty, obviously. Was there evidence of mitigation? People that could have been put up that would have got your guy or your woman a lesser sentence? Were things said on the record in aggravation that could have been countered or contested that your guy, your attorney, trial attorney didn't contest? Your clients say, hey, the solicitor said this and that really ain't true, or it really shifted things around. We'll look into it, because if the judge is giving bad information at sentencing. Sex offender registry, obviously, that's for the rest of the life. Where it's discretionary. Was it challenged? Were all the arguments made? Could they have gotten expert testimony that would have helped keep your client off the sex offender registry? I mean, this stuff is on, sex offenders are on the Attorney General's website. I live on the other side of Rosewood from Shandon, and you look at Shandon where all the law professors and everybody live, and it's just, you look at the AG's map and it's dark, it's midnight, and then you cross Rosewood Drive and the lights up like a friggin' Christmas tree where all the sex offenders are. So, sex offender registry is a big deal, obviously. Client was a victim of domestic abuse. You can get 1/4 domestic, 1/4 parole eligibility if it was a battered spouse, under Tamika Groom's very old case, where they said if you can show this by a preponderance of the evidence. So, I mean, if you got it, if you got this evidence and you get 1/4 parole eligibility, can't imagine why you don't put it up. Should 2 offenses be treated as one? In the old days, we just called this, single course of dealings, or it all happened. 2 armed robberies. You knock off the lunchbox over here, immediately go over to roly-poly right after rob it. Should those be treated as one offense rather than 2? Appellate counsel, we basically have to fail to raise a winning issue, essentially, to be held ineffective. We do appreciate a phone call. If you got something on me, I missed something, I'll admit it. I'm not going to fight you, and I think all my appellate defenders would do the same. But all we ask is don't please call us cold. If you can have us with Skype testimony, we bought the Skype machines, they're there, we can testify by Skype. Sometimes the AG said we don't have the equipment or whatever, but we like to push Skype or telephone testimony. We appreciate you working with us where we can. We have to take appeals from everywhere. I love Beaufort, but it's an entire, may as well be 2 days out of my time to go to Beaufort in person. Love Charleston, the same. Love Horry County if I don't get threatened while I'm down there. But these are all long trips. But if you can call us, we'll be glad to give an affidavit if we can. Again, if we miss an issue where our client would have won, we don't want the client to suffer. We'll always tell the truth, affidavit or otherwise, but we do appreciate a phone call. Anyway, it's 11:40, that's all I got, so we'll break.
Well, Bob's talked through the break, so I guess we'll just keep going.
Bob started late, rather than getting killed.
We are gonna rearrange things just a little bit. Lunch is already here, and so rather than have y'all sitting here thinking about lunch, I'll